Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chug Attorneys and CPAs, tuning in from our San Diego office. Please join me in welcoming attorney Swapnali Kelkar from our Edison, New Jersey office. Hi there, Swapnali, and welcome.
Hey, hi Ariana, how are you? And thanks for inviting me on your Thursday Live.
Thank you so much for taking the time to be here. For today's topic, we will be answering all of your pressing questions on the H-1B cap. Just a quick disclaimer before we get started, this conversation is for informational purposes only. It does not create an attorney-client relationship, so if you do have any questions, please comment them below or email us anytime at info@chug.com. So let's get right into it. Swapnali, can you tell me what's the timeline to file the H-1B cap cases?
I would say the H-1B cap cases timeline to file the case has already begun. The window is a 90 days window which starts from April 1st and it ends on June 30th. So whoever wants to file any cap petitions which were selected in this lottery, they should gear up, they should start working on their petitions and they should make sure that all the petitions reach to USCIS service centers or logbox offices by June 30th.
And what are the factors or points that one should keep in mind to avoid rejection of the H-1B cap petition? And can the employer refile if the case is rejected?
Yeah, that's a great question, I should say, Ariana, because whenever the cap petitions are being prepared, that is the first chance for all those people who wants to be here in H-1B status, wants to work. The employers are also investing a lot of money in hiring these people. So when the cap petition is prepared, the employers or whoever is preparing, even the attorneys preparing the cap petitions, they should be mindful about various things. Like the first thing I would say, they have to be mindful about what type of cap case they are going to file, whether it is a regular cap case or whether it is a master's, cap case. The second point I would say that they have to be mindful about the service center or the basically the location, the filing location where they are going to sit. Previously, the selection notice used to mention the location where the cases needs to be submitted, but nowadays USA has stopped that practice. So wherever is the principal office of the employer is located, it is the and whatever is the logbox related to that zone, the petitioners are required to file cap petitions to that particular location. The third important point which all the employers need to understand is about the filing fees. The filing fees differ based on the total employee count they have, whether they have 25 or less employees or whether they have 25 or more employees. So basis that the filing fees do change. So employers have to be mindful about whether they are filing the petitions with the appropriate filing fees. The fourth pointer I would say they should make sure that they are submitting petitions along with all the pages, along with the recent edition dates of the forms. Make sure that all the relevant fields are marked correctly and then they can actually go ahead and submit the petition. Now, due to some reason, for example, if the petition is being submitted with the USCIS, but probably within 2 weeks or 3 weeks of time, if the petition is rejected, can the petitioners still go ahead and resubmit it? The answer to that question is yes, but again, there is a caveat involved because the filing window, just now we discussed that the filing window ends on June 30th. So if the case is rejected, probably, and if you receive the package back from USCIS probably post June 30th, then unfortunately you will not be able to submit it unless and until there is some kind of an error from USCIS in rejecting. Then you can try resubmitting. So it's really necessary, though we know that the timeline is up till June 30th. I always prefer to submit all these cases well before the deadline so that in case if there are any rejections, employer should still be able to refile these cases. Certainly if there are any such rejections because of any administrative issues or any such issues, employers can still go ahead and resubmit, but they have to be mindful about the timeline. If they are filing it before June 30th, then they are good and they can do so. Yeah.
Absolutely wonderful insights there. And what factors should one consider while preparing any H-1B cap petition? Can you give us some insight there?
Sure. So I would say the H-1B cap petition is nothing but describing about the employment relationship between the petitioner and the beneficiary. And at the same time, it talks about what type of job that person is going to do once he will be in the US. Now, the first important factor which any H-1B employer who wants to file an H-1B petition, H-1B cap petition for their employees, so the first thing they need to be mindful about is the job position which they are offering to their employees. It's necessary that the job duties of that particular position should qualify as a specialty occupation. And when they can qualify as a specialty occupation, for that they have to check whether these type of job duties, to perform these type of job duties, one needs to have a bachelor's degree, and bachelor's degree not in some field, but there has to be a bachelor's degree in the related field. So for example, if someone is trying to submit the H-1B cap petition for a position of software developer, for example, then the employer should actually be mindful about what job duties this person is going to perform, and whether any ordinary person can do it or whether you need someone who has a bachelor's degree in related field. So in such case, I would say if the person who has a degree in probably computer science may be able to perform the job functions of that particular role. So the first thing is to check whether the job description of the role which you are offering needs a person with a bachelor's degree in the related field. The second thing, the employer needs to be mindful about whether the employee whom he is intending to hire in H-1B status, whether he is eligible or whether he qualifies for this particular role. So when I say that, he needs to check his educational background. As I said, like to perform any H-1B specialty occupation work, the person needs to have a bachelor's degree, and that bachelor's degree has to be in related field. Now, the bachelor's degree must be a bachelor's degree which is equivalent to US standards, which is 4 years bachelor's degree. So sometimes it happens that there are people whom the employers are intending to hire from abroad, and those people just having bachelor's degree with 3 years. In that case, it is necessary for the employer to seek the equivalency. They need to get the evaluation done of their academics as well as their experience, because every 3 years of experience is counted as one academic year. So if the employer has an employee who has a 3 years of bachelor's degree, then it's necessary that the person should have a relevant work experience for at least 3 years or more than that, so that employer can actually seek the equivalency. So I would say all these exercises, frankly speaking, are required to be done at the time of registration, because sometimes it may happen that the employer must have just registered the various names of the people without going into the details of their qualification, their experience. And at the time of filing the petition, when we see that, oh, this person has only 3 years of degree and maybe just 1 year of experience, there is a possibility that the person may not be qualifying for the offered role. So I would say these are the basic two things which the employers needs to basically focus on before they prepare any H-1B cap petition. Another one I would say is about their employee count, because basis the employee count, the fees are calculated. And there are certain fees which are calculated not just basis the employee count of that particular petitioner, but while calculating the amount, the petitioner needs to consider whether they have any affiliates or any subsidiaries and what is the employee count of those. And if the count of all these subsidiaries, affiliates, and the employer's employee count, if it is exceeding 25 employees, then the fees change. So this is another, I would say, factor the employer needs to be mindful about when he is trying to prepare the H-1B petition. So these are, I would say, the major factors an employer needs to be mindful about. Yeah.
Wow, really good things to keep in mind there. So another question on that, can the employer who registered the beneficiary's name in the lottery transfer the cap selection to another employer? Is that possible?
Yeah, this is another great question, because we have been receiving these type of queries nowadays that one employer is registering the employee's name in the lottery, the person is selected, but now the employer is not ready to file the H-1B cap petition for probably various reasons, maybe like that project is over, or the client is not ready to hire, or for whatever business reasons the employer might have. Now these beneficiaries are always looking for better opportunities, and sometimes it happens that they may say that, hey, now this employer who has done registration for me, he is not ready to file for my cap petition, but I have another opportunity, I have another job offer from some other employer, but he hasn't done registration for me. Can then I can just use the registration done by employer A and get the petition filed from employer B. So the answer to this question is no, this is not possible. So only employers who are doing or who are registering their employees in the cap lottery and who are selected in the lottery, only those employers can actually go ahead and submit the cap petitions on their behalf. So transferring of the registration, that's not possible. So the employers cannot do that. Even if you have the subsidiaries or affiliate companies, still you cannot do, because there is a possibility that these subsidiaries or affiliates may have a different employer identification number. And when we do the registration, we have to put the employer identification number of each employer. So even if you have your affiliates or subsidiaries, still you cannot transfer the registration done by you to any other employer or to any other company.
Understood. And will any typographical errors on the H-1B cap registration result in the denial of the H-1B petition?
I would say it's not an automatic denial just because there is a discrepancy in the data which is filled in the while by completing the registration, and now while completing the H-1B petition, there is some discrepancy. If there are any typographical errors, it is the burden on the petitioner that he has to make sure that whatever is the data put in the registration and whatever the data is or information he's going to put in the H-1B cap, he has to establish that both the data is is accurate. So I would say the responsibility to establish the accuracy of the data lies on the petitioner. But just because there are some typographical errors, sometimes there is a mistake in the name, sometimes there is an error in the birth date or something. So with the sufficient evidence, employer can overcome these type of errors which happen during the registration. So it's not a straight away denial for the cap petition.
Okay, good to know. So what about the documents related to the project or work assignments? Are those required?
This is another question which many times clients do ask, like, should we add all the project documents if they are placing their employees to third party clients, or if they are placing them in house, whether the project documentation is required. Now, since there is a judgment for the IT serve, USCIS has relaxed that requirement, so we can still go ahead and submit the H-1B cap petitions without any project documents like MSAs or any contracts, or probably any other documents which can establish their work assignment or so. But I still prefer to submit some kind of an documentation which can substantiate that the employer do have specialty occupation work available for the employee, and this is just not any kind of a frivolous petition. And why I'm saying so, because even though USCIS may approve the petition without any such contracts or without any such client documents or any project documents, whenever these petitions are approved, and if these employees are abroad at any point of time, they go for their visa interview. At the consulate nowadays, I have seen a trend that the consulate officers will ask, like, okay, we understand this petition has been approved, but what type of job, what type of work you are going to do, what is the project on which you are going to work? They do ask these documents. And unfortunately, if the employer is unable to provide that at the time of visa interview, then these employees are getting 221Gs. And we all know that 221G is a nightmare. Unless and until you provide the documentations, the consulate officers are not going to grant the visa, and then the whole process of onboarding the employee gets delayed. So it's a waste of time, money, I would say, for the employer. So just to avoid these type of issues at the time of visa interview, it's always advisable for the client employers to submit their cap petitions along with the contracts or some kind of a project documents.
Okay, good to keep in mind. So, what if the H-1B registration was done for the master's quota, but the person doesn't earn the degree at the time of filing the H-1B petition? Is that okay, or is that not allowed?
Uh, I mean, that's not allowed, I would say, because at the time of filing the petition, you must have earned the master's degree. So it's okay if you are trying to register your name under the master's cap quota at the time of registration. If you haven't earned the master's degree, that's fine. But when you're finally submitting the petition, that's the mandate because you are trying to categorize yourself under that master's cap quota, right? And if you haven't earned that degree yet, then in that case, USS will not approve your case. And just because you haven't earned that degree, it's not going to happen that USCIS will consider your case under regular quota. Okay, so if your case is selected under master's quota, it's a mandate for you to establish that you have earned that master's degree at the time of filing the petition. So that's the requirement.
Okay, and if a newly established employer is filing the H-1B petition, does he need to establish the ability to pay the offered wages? Should he have a physical office? Should he have any employees on his payroll?
Yeah, that's another good question because with the new modernization rule, USCIS is trying to encourage, the beneficiary owners, where they can sponsor their H-1Bs through their own entities. Now, when there are any such new startups or new entities, they are trying to file for the H-1B petitions. Most of the time, it happens that they haven't generated any good amount of revenue, and then it's a obligation on every H-1B employer to pay the LCA wages, right? To pay whatever is the offered wage they have committed in the petition and in the LCA. However, there is no such requirement mentioned for the H-1B petitioners that they need to establish their ability to pay, that they can pay the wages they are committed. And of course, as I have said before, that if they can showcase that there is a service agreements with probably the clients from where the revenue can be generated, through these contracts, they can establish that whatever they have committed by signing the LCA, by signing the petition, that they will be paying the prevailing wages or the offered wages to the employees, they can keep up that promise, right? Now, the second question was about whether they should have a physical office. Again, I would say for new startups, it's always advisable to have at least some small but some kind of a physical space instead of having a virtual office. And as per the new modernization rule, it's necessary for the US employer, if it's a startup company who is trying to do the H1s, that they should have some kind of a physical office. So it's always recommended that any H-1B cap employer which is a new entity or a startup, they should have some kind of a physical office where they can post the notices. And yeah, that is definitely beneficial for any new startups if they are filing the H-1B cap. Yeah.
And can you share with us what the most common grounds are for RFEs?
Yeah. Again, so most common grounds for RFEs, the first is always a specialty occupation, that the job which you have offered doesn't qualify as a specialty occupation. And that's why, as I said before, that whenever you're preparing the petition, it's necessary that what type of job you are trying to offer, what type of job duties that person is going to do, you have to evaluate whether you need someone who has a bachelor's degree in the related field to perform those job duties. So if that exercise has already been done, it will be easy for the employer to put that in the petition, write a detailed job description which can basically convince the officer that looks like the job duties are a bit complex, which definitely needs someone who has a bachelor's degree to perform. So specialty occupation is definitely one of the criteria. The second criteria is again whether the beneficiary is eligible or qualifies to perform. We just discussed about this, that we have to evaluate whether the beneficiary's education and experience makes him eligible to perform this type of job duties. One more important aspect is whenever any employees are trying to change their status, the from from any other non-immigrant status to H-1B status. Now, in such cases, it's necessary that at the time of filing the petition, such type of employees must be able to establish substantially that they are maintaining whatever is their current non-immigrant status. So, for example, if someone who is a student who got selected in the lottery now trying to change from F1 to H-1B, the student must be able to establish that yes, at the time of filing the petition, he was maintaining the status. Likewise, maybe anyone who is trying to change their status, maybe L1, H4, TN, any type of non-immigrant status from where you are trying to change to H-1B, it's necessary that you should be able to establish that you are maintaining your non-immigrant status. So that is another aspect. One more aspect of the RFE is fees. Sometimes you submit everything with the proper fees, the case is not rejected for incorrect fees or anything, but still USCIS may go ahead and issue you an RFE, and then they may say that you are putting employee count on the petition about 25 or less, but we have seen that there are multiple H-1B petitions have been filed by you, and according to our record, it looks like that you might have onboarded more than 25 people, so looks like you have calculated the fees incorrectly, and then they will have to provide all the records of their employees. So that can be another ground where USCIS may issue an RFE. So I would say these are basically the common grounds where employers may expect RFE from USCIS.
Okay. And as per the new rule, can H-1B cap petitions be filed if the beneficiary is having a controlling interest in the sponsoring entity?
Yes. So with the new modernization rule, this is another, I would say, a door open for all the people who wanted to start business in the US and still want to pursue or have an H-1B non-immigrant status. So certainly such owners, they can do. And when we say that the controlling interest means all such people who are having probably more than 50% of the stake in the entity, they are considered as having a controlling interest in such entities, and yes, they can sponsor their H-1B cap petitions using their own entity. However, they need to establish that majority of their time will be utilized to perform the specialty occupation work. However, the validity period for these type of petitions is limited to 18 months for their first approval and for their first extension. Otherwise, for all the rest of the cases, the H-1B can be granted for total 3 years. But in such cases where it is filed by the owner who has a controlling interest in the filing entity, then in that case, the validity period is shortened to 18 months. So the employer has to be mindful that he is not going to get a straight away 3 years approval, but that will be shortened to 18 months.
Understood. And can you also discuss the challenges one can face when they're changing their status to H-1B?
Yeah, as I said, right now the challenges will be to establish that they are maintaining their current non-immigrant status, right? Now let us take up an example. If someone who is in L1 status, right, and probably this person is in L1 status for almost more than 5.5 years, and if now he is trying to transfer his or change his status from L1 to H-1B, there is a possibility that he's not going to get the new H-1B for a complete 6 years, but he is entitled to be in H-1B status just for probably 6 months. Likewise, if someone is trying to change his status from F1 to H-1B, the student needs to establish that he is maintaining his status. For example, if he is on OPT, he needs to establish that he is complying with the OPT rules. He is employed, he has to showcase the pay statements, he has to showcase that he is not violating any terms and conditions. If he is currently pursuing something, then he should showcase that he has given the physical attendance, paid the fees and everything. So certainly it is necessary for every non-immigrant with some kind of an other status who is trying to change to the H-1B status that they must be able to establish that they are completely maintaining their status at the time of filing the petition.
Well, I appreciate all of your insight today. I have one more question for you. What's the best way to prepare for the H-1B visa interview post the approval of the petition?
Yeah, so I would say, if the petition is prepared, properly and correctly, then the visa interview becomes easy. So if anyone wants to prepare for their visa interview, definitely they need to be acquainted with the I-129 petition which is filed on their behalf. They should also know, the terms and conditions of their employment. They should take a look of the LCA. They should be aware of what is the work location, what salary is being offered to them. They should also be aware of whether the employer is offering them any kind of other employment benefits, because these are typically the common questions the officers do ask, the concert officers do ask at the time of interview. At the same time, the employee should be aware of the project on which they are they will be assigned or they will be working on. They should also be aware of who will be their supervisors, who will supervise their work, and they should also be aware of the work location, whether it is a work location which is a client side or whether this is any in-house role. And if they get acquainted themselves with the petition, with the LCA, with the support letter, probably with the job duties and job description, what they are going to perform, probably it will be easy for them to successfully go through the visa interview.
Wonderful insights. Well, I appreciate you so much for taking the time to join us, Swapnali, and answer all of our pressing questions on this topic. This is all we have time for today, so this brings us to the end of our conversation. Thank you, everybody, for tuning in and joining us. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have any questions or suggestions, email us anytime, info@chuk.com. Let us know what topic you want to see next, and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care of everybody. Thank you again for joining us. Thank you, Swapnali.
Thank you.